Legal Services at Texas Immigration Law Council. So before I turn to our panelists, I'm going to give an overview of the governor's executive order, and then each panelist will speak for 10 to 15 minutes, with any remaining time then dedicated to Q&A. If you have any questions for our panelists, please post those questions in the chat. So let me just start with an overview of the executive order. The governor issued Executive Order GA 46 on August 8th, and the order directs the Texas Health and Human Services Commission to collect information from Texas public hospitals on the care they provide to undocumented immigrants. And then a few weeks ago, HHSC issued some guidance on this order and says that their guidance applies to all, quote, hospital providers, and gives them instructions about what they need to do during the patient intake process and gives instructions for quarterly reporting. So during the patient intake process, a hospital provider must ask all patients whether they are citizens or lawfully present immigrants, or whether they're not lawfully present immigrants. They then must notify patients that their response to this question will not affect the patient care that they receive from the hospital provider. The guidance also directs hospital providers to then report certain information to HHSC on a quarterly basis. Specifically, they have to report the number of monthly inpatient discharges and emergency department visits, and the total monthly inpatient cost and emergency department visit costs. And they have to do this for all patients. And then they need to also do this for Medicaid and Medicaid patients, as well as for CHIP patients. And then within each category, they have to further break this down by patients who are lawfully present or citizens, and for patients that are not lawfully present, so immigrants. The guidance also states that reporting these costs should be based on the hospital's actual cost as opposed to their charges, and it excludes revenue offsets. As for timing, the hospital should start collecting this information from patients on November 1st, so that's this Friday, and then report the information on a quarterly basis beginning on March 1st. Now, the governor has asserted that their authority for this is based on a previously issued disaster proclamation that was issued in May 2021. And that was issued under Section 418.04 of the Texas Government Code. And the statute authorizes the governor to declare state of a disaster, and then when they do so, it triggers various emergency authorities, including the authority for the governor to suspend various regulatory rules. So this May 2021 disaster proclamation declared that there's an ongoing surge of individuals unlawfully crossing the Texas-Mexico border, and that this poses an ongoing imminent threat of disaster for a number of Texas counties and affected state agencies. The governor also offered various policy justifications for the executive order. So specifically, the order states that the federal government, quote, adopted open border policies that invite mass illegal entry into Texas, and that this has contributed to the growth of uncompensated medical costs. It furthermore asserts that Texas ultimately bears the cost associated with public financial support for medical care for these individuals who are not lawfully present in the United States in the form of higher taxes, and that providing care to these individuals imposes burdens on the Texas healthcare system and increases the cost of medical care for all Texans. The order concludes then with an assertion that the federal government should reimburse Texas for these costs. So I'm now going to turn things over to our first panelist, and that would be my colleague, Seth Chandler.
Well, thank you very much, Jessica. And I'm going to share my screen so you can see some slides. And if all goes well, you should now be able to see something that says Executive Order 46. Let me just stress that the views expressed here are my own and don't necessarily reflect those of the University of Houston. And here I'm just going to show you pictures. Here's a picture of what the order looks like. Here is the actual text of the directive. Here are the provisions of the Texas regulatory statute that Texas regulations that Governor Abbott is invoking in order to take this action. Here are some of the provisions, and here's actually a picture of the spreadsheet that hospitals are obliged to fill out, which you will notice does include this provision that patients do not actually have to respond to questions about whether they are unlawfully present. But mostly what I want to talk about today are the legal issues that are raised by Governor Abbott's order. And I would say there are a number of potential challenges to what the governor has done, although I think the governor has respectable legal responses to each of them that's going to make it a difficult uphill battle for people who do not like at all what the governor has done. The first is that the requirement violates the Medicaid statute itself, that Medicaid does not permit the conditioning of hospitals to participate on their interrogating people about their immigration status, and that even if it might permit that, that constitutes a change in the content of the plan for which federal waiver or federal approval was necessary. A second argument might be that although perhaps the Texas legislature could have enacted such a requirement, that the existence of an emergency, particularly one that is not of a traditional sort, means that Governor Abbott cannot do this on his own, that there's a separation of powers, a state separation of powers issue that's created by what the governor has done. A third legal issue to identify is the at least potential for there to be violations of HIPAA privacy here, and that those violations might potentially occur even though the data that's being submitted by the spreadsheet is at least initially on the aggregate level. I think we're up to fourth argument is that by basically requiring people to who come to the emergency room to disclose their immigration status on intake, at least indirectly violates the federal EMTALA statute. And one could imagine future, you've got a future US citizen in the womb and for whom we are going to have to take care of them for the next 70, 80 years. Do you really want that person injured as a result of a refusal to provide care during labor? And finally, there's some possibility that one could tease out certainly a tension between the spirit of the governor's order, which is not particularly welcoming to people unlawfully present, with the immigration policy adopted by the federal government, which balances other concerns, foreign relations, and the like. All right, so what would Governor Abbott or Ken Paxton argue if they were here, and they were invited, but what would they say? They would first of all say that the hospital doesn't have standing to assert the rights of undocumented immigrants, that really what you're complaining about is an effect on undocumented immigrants, let them bring the claim. Secondly, under Medicaid and under a Supreme Court case called Armstrong versus Exceptional Child Center, there is not really a general private right of action for alleged violations of the Supremacy Clause, that you need to find something in the particular federal statutes that you say are doing the preempting that authorizes a right of action. I will note, curiously, the Armstrong case rests on sort of a Chevron idea of deferring to the executive regulatory authorities because they have a big picture about what's going on with the statute. And since Chevron is no longer alive and we live in a world of Loper Bright, one might wonder whether the 5-4 decision in Armstrong is still good law. But for the meantime, it's good law, and it does pose an obstacle to people who want to sue and say that this governor's policy is preempted by various statutes. All right. If I were Governor Abbott, I'd say that there was no HIPAA violation here because there is no individually identifiable health information that is ever transmitted. The spreadsheet just calls for aggregate numbers. How many people did you see? What did it cost? And it doesn't give information from which the governor could immediately at least tease out who those people were so that they could send the ICE agent over there. There's no EMTALA violation, the governor would say, because as it makes clear, the hospitals are still obliged to provide emergency care. It might discourage some people from seeking such care, but the obligation of EMTALA is to provide care for people who seek it, not to advertise that you offer emergency care. And finally, on the separation of power points, I think the governor would basically say that he does have authority under the Chapter 418 of the Government Code to sort of centralize authority during an emergency, and that he believes it's appropriate to use that authority to determine the immigration status because it's costing Texas a lot of money, and that the judiciary should not get involved in the second guessing of the governor as to when an emergency exists. Okay, so that's an overview of the legal issues involved. Let's go circle back on each of these. And let me first look at Medicaid and ask whether the Medicaid statute itself might prohibit Texas from taking these actions. So the first thing to say is that Abbott's claims are presumably no better than would be the case were the state agencies themselves, to HHSC, for example, to have required that hospitals engage in these immigration interrogations. If those agencies would not have the right to change effectively the Medicaid plan in this way, Abbott doesn't have any better claim just because he declares it to be an emergency. And so why do I think this is important? I think it's potentially important because, as I said, under the Armstrong versus Exceptional Child Center case, so long as that case lasts, you can't just say a statute violates the supremacy clause. You've got to show some specific federal statute that gives you either an explicit or implicit right of action. And so if I were to argue that it does violate the Medicaid statute, what I would say is that the Medicaid statute requires that the state plan be consistent with efficiency, economy, and quality of care. And the fact that a state even has a worthy goal, that is, people disagree on how much of a burden or net burden these immigrants are to the state Texas. Is it really an emergency? But take a goal that many people might think was worthy, which is that hospitals participating in Medicaid have to have fully staffed child care center for their staff. Okay, that might be a splendid idea, but pushing those costs onto Medicaid providers is problematic because it raises the cost of the Medicaid program. And immigration control is not generally a goal of the Medicaid statute. And so one might wonder whether the additional burdening of Medicaid with this sort of immigration inquiry is appropriate. And so that's something that I think might be worth investigating further. The second thing is, okay, well, maybe ultimately it's okay. It's not inconsistent with efficiency, economy, and quality of care. Nonetheless, it is arguably a material change in the Texas Medicaid program, and Texas seeks changes in plan all the time. I looked, and I think we've sought out 9 changes to our Medicaid plan already this year. For other things, maybe this should have gone to a submission to CMS, which of course it would have denied, but maybe they should have asked. And so the question here is going to be whether the change is material or not. It doesn't have to, the state doesn't have to get CMS approval every time, it requires that pencils be sharpened, but nonetheless, maybe this is enough of a change. So the issue again is going to be, though, do hospitals get to complain about this? Or is this really up to the Biden administration for its remaining days to challenge it and say, Texas, what you are doing is inconsistent with the plan that we approved? To date, as far as I know, the Biden administration has not asserted that. Maybe with the statute the regulation actually taking effect on Friday, they will do something, but they may have other things on their mind in the time allotted. All right, so we've got state separation of powers issues. And here, let me just highlight the Texas Constitution for you, which says in Article 2, the powers of the government of the state of Texas shall be divided into 3 distinct departments, and no person or collection persons being of one of these departments shall exercise any power properly attached to either of the others, except in the instances herein expressly permitted. So this is the general idea. And what does the governor get to do? The governor gets to cause the laws to be faithfully executed, and he gets to convene the legislature for extraordinary sessions. He gets to appoint people, but there is no explicit grant in the Texas Constitution of emergency powers that relieve the legislature of what would ordinarily be its job of deciding, how hospitals in the state are to be regulated. Now, if I were the governor, I would say that, hey, Chapter 418 of the Government Code has been around for many, many years. And why is it around? And why has no one sort of generally said it's unconstitutional? It's because we don't want just one law to be faithfully executed. We want all the laws to be faithfully executed. And the existence of an emergency maybe requires that some additional steps be taken. Of course, this depends a little bit on how credible you think the governor's claim is that there really is a statewide emergency that's been created. And some people might wonder why, if the emergency existed as early as 2021, and why arguably now that immigration is a little bit down, why the emergency suddenly exists in the hospital sphere in 2024. But, the counter argument is that's a nice, clever point, Professor Chandler, but that's second guessing, and the judiciary shouldn't get involved in that. All right. The one party that could tell the governor to stop, clearly could tell the governor you're wrong, is the Texas legislature. The legislature is not currently in session, and even if it were in session, I have some doubts whether the presently constituted legislature would tell the governor that he was wrong on this point. And so the real question is there any judicial check on the governor? Can the judiciary say, hey, there's no emergency here? Or maybe there's an emergency, but it just doesn't justify what you're doing. And the answer here is, well, there's nothing explicit that says that the Texas legislature can check. There are some recent cases, mostly dealing with COVID, in which the courts entertained the idea as to whether the governor had acted improperly. Some of those arose in challenges by local governments. And so one question one might have is whether local authorities that were less enthusiastic about the ideology behind Governor Abbott's order might say, well, maybe you can do this sort of immigration checking in Bexar County or in, I don't know, San Jacinto County, but not here in Harris County, or is there really an emergency in Childress County? And so this was actually the issue that arose in debates about masking laws, regulations during COVID, and the Texas Supreme Court basically sided in favor of the governor. And again, when I was sort of saying at the beginning that I wasn't optimistic or enthusiastic about court challenges, one of the reasons is this case, which talks about how the Disaster Act grants ultimate authority to the governor, who may countermand the orders of his designated agents when they conflict with his preferred method of responding to a disaster. Now, that case is distinguishable, and we can talk about that if we want, but at least it's not a great starting point for those who wish that a local authority would challenge this. I think Professor Mantell talked about the motivations for the governor's claim. And if you're wondering, well, why aren't I talking about more case law? The answer is, well, I looked pretty hard and there just isn't a lot of case law on this point. Let me turn quickly to HIPAA. And if Jessica, if you could tell me how much time I have left, that would be a great service. How am I doing? 2 minutes. All right. HIPAA in a nutshell. All right. So HIPAA says that a covered entity or business associate may not use or disclose protected health information except as permitted or required by this subpart. All right, and we teach a whole course on HIPAA, so I'm about to condense in 2 minutes an entire course. But there's this idea of protected health information. That's the thing that's prohibited. And what is protected health information? Protected health information is individually identifiable health information. And what's individually identifiable health information? It's a subset of health information, including demographic information, which arguably includes immigration status, that's created by a healthcare provider and relates to their health needs or provision of healthcare. So that presumably, if Methodist Hospital were to go out and disclose, hey, guess who visited us today? Professor Chandler. And we're not going to tell you what for, but we are going to tell everyone, hey, Professor Chandler was at the hospital today. That would be a HIPAA violation because it identifies me and it tells people that I am seeking care. Just if one considers immigration status to be a form of demographic information, or by saying, Mary Sanchez, the illegal immigrant, was at Methodist Hospital today, I think that's a HIPAA violation. What the governor's going to say, though, is, hey, we're not telling hospitals to do that. We're just telling them to gather this information, aggregate it, and send it to us in a spreadsheet. And if that is all they're doing, and that is all they ever do, I think it's a very hard argument that that is a HIPAA violation. It only conceivably becomes a HIPAA violation if the state says, hey, who exactly are those 23 people? We want to know. We don't believe that there were only 3. We think there were more. Or we think there were less. And so I am going to stop there and leave it to Dr. Dark to talk about EMTALA and others to talk about immigration. Thanks.
All right, well, thank you very much, Seth, for the lead-in. I want to get on EMTALA, but since you just finished up on HIPAA, I feel like it's reasonable to kind of start there too. So from the physician perspective, HIPAA means I can't tell anybody or disclose that personal health information without the patient's consent. There are some exceptions to those rules. You know, sometimes we have mandatory reporting situations like child abuse, elder abuse, etc. But I'm not allowed to tell all of Houston that Mattress Mac is in the hospital for something. Now, Mattress Mac himself is allowed to go out and film a commercial, apparently, in the hospital if he so chooses, but that's the patient disclosing that information and not us on the physician side of things. There is one kind of, I guess, exception to this that might be relevant, and I'm going to try to stay away from the legal aspect of it because I'm not a lawyer and I don't even want to pretend that I'm one on a webinar. But there are some provisions that allow us, when we're in the hospital and let's say the police are in the process of investigating a crime, to provide them with some kind of information. The question of whether or not being undocumented in the United States is a crime, I'll leave that for our lawyers, and I think especially Kristen will probably handle that. But let me jump into EMTALA, because that actually is sort of the ethical basis of emergency medicine. And it's something that says that whenever someone comes to an emergency department for care, that we are required to provide treatment to that person without any respect to their ability to pay or any other situation. And this leads to a lot of uncompensated care. If you go and look up some studies, there's one from the American Medical Association. It's about 20 years old now, but it estimated that emergency physicians on average gave away about $138,000 per doctor of what we call bad debt or uncompensated care. And this is, of course, to people of all stripes. It's, you know, immigrants, citizens, you know, every single person. And, you know, that's something that we know in my specialty that we face on a day-to-day basis is the burden of uncompensated care, because EMTALA provides what we would like to say an unfunded mandate to do so. Now, we're happy to do it, but at the same time, it'd be nice to be compensated for what we do. Both the American College of Emergency Physicians as well as the Emergency Medicine Residents Association has actual policy out there that talks about how do we deal with care of undocumented persons. And one of the tenets in both of those things is that we shouldn't hinder people's care based on asking about their status. And essentially, we should treat every patient regardless of their national origin, their race, their gender, their political beliefs the same. We're here to do medicine. We're not here to do, you know, immigrations enforcement. And so I think when we look at it from an EMTALA standpoint, that's what we ought to be doing, and we shouldn't be putting up any stumbling blocks or hindrances for people. Now, the state is talking about how much it costs for uncompensated care. And one thing to consider, there was an estimate for some of the hospitals that deal disproportionately with that. Texas estimates maybe somewhere in the $5 billion range annually as to how much they're subsidizing the treatment of uncompensated care. So for one, it'd be interesting to know the numbers and figure out how much uncompensated care there actually is. But I'd rather not just know it based on whether someone's unlawfully present, but rather everybody. And let's get an assessment of all of the uncompensated care out there so that we can better fund our emergency care systems. That said, I think the real difficulty with something like this is because of EMTALA, does it pose a burden on the patient when they show up if the hospital registration people, or as some of the guidance would say, the hospital's physicians have to ask these questions themselves. And if that's the case, there's an example I like to bring up out of South Carolina. Many years ago, emergency departments in South Carolina wanted to put up signs that literally would tell people, we do not treat chronic pain with opioid medications in our emergency department. And this would be after the patient had checked in, gets to their room, and there would be signs posted. They actually asked the regional CMS about that, about the signage, and they were told if you did that, it would potentially be an EMTALA violation, because the treatment of emergency medical condition includes, anything of severe intensity to cause, life-threatening, but also pain was listed in the definition of what an emergency medical condition might entail. And if you're not treating someone's pain, or in this case, if you're in fact telling them that you're not going to treat them one way or the other, that could be a stumbling block. And so I would look at this similar to that. Are we doing a disservice to people by simply even asking the question, and where and when in that process we ask the question? Because depending on how that's done, that potentially could cause there to be an EMTALA violation. But I think there's a lot of, devil in the details as to how that's implemented. And I think we'll probably come back to that in some of the Q&A, but I just wanted to lead there and let Kristen take it from there.
Great. Thank you, and good afternoon, everyone. Give me one moment as I find my presentation. There it is. Okay. And I will go ahead and put it on presenter mode. So give me 1 second. Okay, so I have an agenda that I'm going to get through that's going to begin with the history of immigration enforcement at hospitals, as well as the criminalization of immigrants in Texas. I'm then going to move to lawful presence, and then we'll talk about information collection, information identification and storage, and what is next on the horizon, how GA46 may interact with current and future laws. So I want to begin briefly by just noting that not just Texas, but nationally, there is a history of immigration enforcement at hospitals. Now, hospitals are defined under this executive order as acute care hospitals. And so there are a plethora of services provided by acute care hospitals in our state. But I wanted to highlight how vulnerable people are when they find themselves seeking emergency care for either themselves or a loved one, and how scary this can be for somebody who may or may not have lawful presence, who is an immigrant in our state. And I wanted to highlight 2 cases in Texas. So these were recent cases. In 2015, there was a case of Blanca Borrego, who was in her OB's office and in an exam room, was arrested in her exam room here in Texas after the intake specialist believed that she had presented a fake ID or fake driver's license at the time of intake. In addition, there was the case of Maria Rosa, who is a 10-year-old patient, cerebral palsy, that was in an ambulance on her way to seek emergency surgery in Corpus Christi when she was stopped at a checkpoint, and it was determined that she was not lawfully present. Border Patrol followed her to the hospital, waited outside the hospital room, and as soon as the surgery was completed, they took the 10-year-old into custody to initiate deportation proceedings. So there are other cases from across the country, but those are 2 that I wanted to highlight just to show, again, that there is this history of seeking immigration enforcement at hospitals. In addition, I did want to mention that there also is a history of criminalization of immigrants in our state. And in fact, the exact same disaster declaration that is being used to promulgate GA46 was the same disaster declaration that was used in 2021 when Texas initiated Operation Lone Star. So Operation Lone Star was, and this is the same, by the way, the same disaster declaration that has been renewed every 30 days since the spring of 2021. And so when that disaster was first declared, Operation Lone Star began, and that is the militarization and the criminalization of immigration at the Texas-Mexico border by a series of policy and law enforcement changes that deployed Texas National Guard and Texas Department of Public Safety troops to the border to arrest migrants in mass under the guise of a criminal trespass misdemeanor violation. And so what we've seen since 2021 are, again, migrants being criminalized for coming to our state. We then saw an enhancement of Operation Lone Star in Senate Bill 4, which was passed in 2023. And that is the enactment of a state immigration system where illegal entry, re-entry, and failure to return to a foreign nation will all be new state criminal offenses, turning state peace officers into de facto ICE agents and state judges into de facto immigration judges with the authority to deport migrants. That bill is currently pending at the Fifth Circuit Court of Appeals and has been on a stay since February of 2024. And then we also saw in 2024, the state began to accuse organizations that serve immigrants with accusations such as a human smuggling operation of a stash house, and that there was an Annunciation House, which is the most famous case that is still also ongoing in pending litigation. And the director of that of Annunciation House has said, if the work of Annunciation House is illegal, so too is the work of our local hospitals, schools, and food banks. So I want to then next talk about lawful presence. We know that the executive order states that hospitals will be directed to collect information regarding patients who are not lawfully present. Surely there's a definition of lawful presence somewhere that we can look to. However, I'm here to tell you that nowhere in the executive order, nowhere in the HHSC regulations, nowhere in state law, and nowhere in federal law is lawful presence actually defined. And in fact, lawful presence is not defined in one specific statute. Instead, it is a term used across various federal immigration laws and also in our state laws as well, because it's used but also not defined in Senate Bill 4. To describe individuals who are legally in the United States under certain recognized statutes. However, the specifics of who qualifies as lawfully present vary depending on the context. So if it's not defined in federal or state statute, let's look to the courts and see what the courts have said. So there was a case, United States versus Texas, that went up to the US Supreme Court. Early in the argument, Chief Justice Roberts noted that the United States has asserted that individuals covered by this executive order, DAPA, are lawfully present, but then on the following page said that individuals with deferred action are actually present in violation of the law. The Chief Justice then expressed some confusion by stating, lawfully present doesn't mean you're legally present. Following up, Justice Alito then asked, how can it be lawful to work here, but not lawful to be here? And so this is really what I want to focus on, how this is confusing, not just for lawmakers, not just for Supreme Court justices, but clearly for us, citizens and people working in the healthcare industry that are trying to make sense of this executive order. So let's look at where the term lawful presence has been used in other statutes. So we look at the Social Security Act, and there is a definition, not per se, but there are some categories and some very complicated charts. There are 8 categories of qualified aliens under the lawful presence Social Security Administration. They actually then provide us a table that the Department of Homeland Security uses to consider whether an alien is lawfully present in the US for purposes of Social Security Administration. So I don't expect you all to even necessarily be able to see this, let alone make sense of this, but I only use this to highlight the complexities. So these are all the different categories. We then go on. It still then continues, well, if you're an alien who has been inspected and then admitted into the United States, but has not violated the terms of immigration status, which they were admitted or which they have changed after admission, then use this chart. So this is the other chart that's provided. We then go to, okay, what about people who are permitted to come into the United States for humanitarian or other public policy reasons? Well, that's a whole other chart, and this is the chart that is provided. So in terms of after that, well, what about somebody who has an asylum claim pending or withholding of removal pending? Well, then you need to use this table. And then there's a provision, and then there's some additional requirements, and then there's some additional explanation. Well, what about people who are not listed? Some examples of people who are not lawfully present. So the Social Security Act website then says, well, the following are not among those that are lawfully present, but they are lawfully present if they show that they are otherwise lawfully present in the US. So I provide this just to highlight, even within the federal government, there's a lot of confusion about who qualifies as being lawfully present. Let's see what the state officials have done. This is the Texas Proof of Lawful Present for Driver's License Applicants. This is DPS's website for those that are seeking to obtain a Texas driver's license. And there are various categories of what types of visas, what type of presence, how long somebody has been here, what type of visa, what type of proof, and what type of acceptable documentations would be required. So again, even trying to simplify it for purposes of obtaining a driver's license and showing proof is quite complicated. So in terms of, let's talk about what some other types of lawful presence that most of us would presume. So for example, a DACA recipient, somebody who has TPS, so temporary protected status, deferred action for childhood arrivals. What about the Cuba, Haiti, Nicaragua, Venezuela visa program? These are all executive actions that have happened under the Biden administration that most of us would presume those recipients are lawfully present. However, Texas has taken an opposite position in multiple legal briefs and litigation against the DACA program, litigation against TPS, litigation against the CHNV parole program, and has specifically said, our Attorney General has specifically said that DACA recipients are considered to have only temporary protection from deportation. They do not have lawful presence. So does lawful presence also exclude DACA recipients in Texas? It does if you listen to the Attorney General. In addition, we also have officials from a future potential Trump administration that has said Haitians that are legally here are actually illegal. So again, the CHNV program, the Cuba, Haiti, Nicaragua, Venezuela program, are they here with lawful presence? Not according to JD Vance. Is a DACA recipient that has lived his or her almost entire life in Texas have lawful presence? Not if you were to listen to our Attorney General. And it's been very clear that the future Trump administration will basically make the position that any executive order initiated by this current administration is an illegal action and does not make an alien legal, according to JD Vance. So let's talk about information collection. So the executive order specifically says that when collecting information about a patient's immigration status, hospitals must provide notification as required by federal law that the response will not affect patient care. Great. So when we look at the HHSC regulations, they specifically provide for that. They specifically state that hospitals are going to be required to do the number of visits for individuals with status that are not lawfully present individuals with status that are lawfully present or a U.S. citizen, and then also the total number of ED visits for individuals, including patients who decline to respond. So when we talk about what is going to be required at this intake process, this is an executive order that is a requirement on hospitals. It is not a requirement on patients. So a patient declining is a patient complying. And so limiting immigration status collection to self-disclosure by patient after being informed that a response or no response will not affect patient care. In addition, consider adding categories of 1, United States citizens / lawfully present, 2, not lawfully present, and then 3, because this is contemplated by the HHSC regulation about declining to answer, it's also, given the fact that there is no definition of lawful presence, that category could also be combined with a /unsure. Because again, hospitals are not immigration lawyers. Hospitals are not going to have the expertise to make these determinations on the spot in an emergency room, nor should they. Obviously, as Dr. Dark talked about, we want hospitals providing emergency care. And if United States Supreme Court justices are confused about what lawful presence is, it is safe to assume that an intake specialist at an emergency room is also going to have that level of confusion. And again, by adding that category of decline to answer / unsure, we can be, again, in compliance with GA 46, but also removing the whole issue with the uncertainty. And again, consider adopting narrow, standardized approaches that limit profiling and protect patient trust. So let's talk a little bit about information identification and storage. So it's clear that the AMA does consider immigration status to be protected health information under HIPAA. However, that information can be disclosed if it's related to a crime required by law or pursuant to a subpoena. For purposes of living in Texas, we should presume that the exceptions will swallow the HIPAA law. And that is because we have a very expansive document demands and document requests to medical providers, to providers of services to immigrants, in various different ways, various document demands being made to healthcare providers, including lots of different demands identifying aliens who you've provided services to. So these are some examples of some of the document requests that organizations have received just this year by the Texas Attorney General. And so ensuring that only non-identifying aggregate data regarding healthcare costs is collected and that immigration status not be embedded within medical charts, health records, or other identifying files. And this is both, again, to protect medical care providers from a potential HIPAA or EMTALA violation. There is also ways to structure internal reporting to collect and produce anonymized aggregated financial data in order to streamline reporting and to protect patient identities. Using secure databases with clear data retention policies, and presume that any type of information that is requested and that is protected health information could be accessible through an investigative demand by the Attorney General in Texas. And so thinking about what makes sense, and again, the executive order says nothing about identification. Its only concern is about costs associated. And so talking about the best practices in terms of anonymizing and aggregating only financial data and not having this type of information follow in a patient's medical record. So I wanted to end with how GA 46 may interact with current and future laws, because we are at a time where, for example, Senate Bill 4 could come back at any moment. And again, Senate Bill 4 is this creation of new immigration-related state offenses. And although there is an exception for enforcement on the premises or grounds of a healthcare facility, there are two important, I guess, exceptions to the exception. One is, in order to fall under that exception, you actually have to be the patient who is receiving treatment. So, for example, it would not protect a parent taking a child to a hospital if the child is the one that is receiving treatment. In addition, it does not prevent law enforcement from receiving and arresting patients for Senate Bill 4 offense outside of the premises and grounds. So only premises and grounds are protected. There is a history of having immigration enforcement agents waiting outside premises and grounds. And so in terms of that could interact by causing a lot of people to potentially be subject to arrest for Senate Bill 4. In addition, the Attorney General investigations, as I've mentioned, have been very broad and have been very focused on trying to obtain identities and lists of undocumented people at other organizations, including the Annunciation House, including an organization that provides legal services to immigrants, wanting to know names, wanting to get identification and immigration statuses of clients that legal services organizations are representing. The other thing I did want to mention is that we do have an upcoming Texas legislative session that starts in January of 2025, where some of the priorities for legislative priorities are to end all subsidies for illegal aliens except for emergency medical care. So what that, and that also would include K through 12 education. But importantly, because acute care hospitals provide more than just emergency care, medical care, it's also possible that this information could be used in the future to deny subsidies for non-emergency care. In addition, there is a priority to create a new crime with mandatory fines and jail time for individuals, corporations, and nonprofits from assisting or inciting illegal entry. That argument has been made, for example, in the case of the Annunciation House, that somehow providing humanitarian services to immigrants encourages more immigrants to illegally enter, and therefore that could in effect be used against hospitals in the future. In addition, there is a mass deportation campaign that has been a top priority of a future Trump administration. And even though there is current sensitive location guidance that says that immigration enforcement should not occur at sensitive locations such as schools, place of worship, and hospitals, that is not binding and could easily be used in a mass deportation campaign in conjunction with G846. So with that, I'm going to end my time and available, I think we have about 10 minutes left, so available for any questions.
Thank you all so much for your really informative presentations. So to get things started, I just wanted to follow up on one thing Kristen said, and I know Seth was answering this a little bit in the Q&A, but since we had several questions about it, I just wanted to put it out there again, which is the question of, can a patient refuse to respond, and can they invoke the Fifth Amendment? And so I know, Kristen, you addressed that in your remarks, but Seth, do you have anything that you'd like to add to that?
Yeah, I think it's quite clear that you can refuse to answer. The spreadsheet contemplates that. Moreover, there don't appear to be any consequences to refusing to answer, and you don't need to plead the Fifth Amendment. And I wouldn't advise actually pleading the Fifth Amendment because that can sometimes have collateral consequences. It's not as clean a thing as it may appear on TV. And so one thing hospital could do, if hospitals are not particularly sympathetic to the objectives of this executive order, is to make clear to their intake clerks that those intake clerks in turn should preface their questioning of the patient by saying, you do not have to answer this question. This is completely voluntary, but would you like us to know that you are unlawfully present in the United States? And if the person says, no, I really don't want you to know about that, it's none of your business any more than, you know, my sexual orientation or whether I go to church or other things, private information. No. I believe that as it stands, that does not violate the executive order. Now, could there be GA 46A in which that little option is diminished, possibly, but for the meantime, I think hospitals can inform patients quite clearly that they are not obligated to answer the question. And we've seen this, for example, sometimes you'll get a form that says, would you like to tell us what race you are? And there'll be an option that says, no, I'd prefer not to disclose it. So I don't believe one needs to plead the fifth. I simply believe that hospitals can advise patients they don't need to answer. Immigration advocacy groups could certainly advise members of their communities that there's no obligation to answer the question. And I think that's perfectly permissible under the order as it stands.
If I could jump in a little bit here, Jessica, too. I spoke with some people that do registration where I work, and most of the on-the-ground people that go from bed to bed to talk to patients and get their demographic information were not even really aware that this is coming through. I spoke with one of their supervisors, and part of the reason is some of this stuff is already just asked in general in normal emergency medicine or hospital intake process. They talk about what's your religion, are you a US citizen or not. I don't believe they get into the details of lawfully present, not lawfully present. So that's something that needs to be added in for these hospitals. And I liked Kristen's way of approaching it as having these different categories so that you can get the answer that's required for reporting, but you don't really have to deal with the complexity of 5 different pages of really complex charts, because no one's got that kind of time to deal with that in the emergency setting.
Great, thank you. So I want to go back to something, Dr. Dark, that you raised, which was kind of at what point in the process you may ask the question about someone's citizenship status or immigration status. And it seems that the guidance coming from the state agency is that this should be done as soon as possible, or in the patient intake process. But you seem to suggest that maybe it could be done later in the process, and that maybe even under EMTALA, it should be done later in the process to not create, incorrectly a signal of you won't be treated if you don't answer this question.
Yeah, I would argue that it should be done towards the end, but many hospitals don't wait until the end to do their registration. I vividly remember this at one hospital where I worked at, where I walked in, I saw a patient who I figured needed like a surgery to figure out, do they have an appendicitis or not? And there's a button that we click when we go see patients that says MSE, medical screening exam, because all the computer programs, all the electronic records are tracking this. But registration sees when you click that button so that they know, oh, it's safe for me to go into the room now because they've been seen by the physician. Literally within a minute or two of me walking out of the room, registration walked into the room, told the patient, well, here's your insurance, this is your copay. I need a check for however many hundreds of dollars to cover their copay. Now, in my mind, is that something where you're actually violating EMTALA by letting them know their financial responsibility up in advance? Because to me, the MSC is not complete until I've figured out whether or not the emergency medical condition exists. And I'm not going to know that until after I get the labs, after I get the CAT scan, and figure out, is there an appendicitis or not? So to me, that should happen at the end of that process, as opposed to in the middle of that process. Where this takes place, specifically for this, I think if they're trying to go for the spirit of not hindering care, it needs to be at the end.
So can I just add on to that and say, those are interesting arguments by Dr. Dark, but the regulation takes a different perspective. That is, you might lobby that HHSC change its rules so that it doesn't have to take place during the intake process. But for better or worse, the current regulation contemplates that it does so. And so the legal question, seems to me, would be whether the insistence that it take place during intake amounts to a violation of EMTALA. I think that's going to be a hard argument to make. It may violate the spirit of EMTALA, but not the letter, and particularly, well, I'll stop there.
Okay. So you all touched on possible legal challenges. Professor Chandler, you did in particular. Are you all hearing about people that are thinking of filing litigation, challenging either the executive order or the HHSC guidelines that have been issued under the order?
I've not heard of anything. I mentioned it. We actually had our annual emergency physician annual conference in Vegas earlier in this month. And I attended a lecture where they mentioned it. Most people, and this is a national audience, had no idea about this, but upon hearing it, were highly concerned in the emergency physician community, again, because of those potential EMTALA allegations, which again, that's our moral ethic and how we deliver care. And I think we want to make sure that we're able to deliver care in a way where it doesn't hinder someone's ability to access emergency care.
I'd only say, actually, it's kind of interesting. If hospitals don't even know about this and they're not implementing it, you don't need a court challenge. It won't be implemented. But I'm being somewhat facetious. But I think hospitals do need to come up with clear guidance for their intake people, or they're going to find themselves, angering people who give them significant amounts of money. So they need to come up with some clear policies. Ms. Etter came up with some, I think, very good ideas on that score.
All right, thank you. So what if you have the ER physician or someone who works in the administration, maybe in the intake process, that is told by a patient, yes, I'm not, lawfully present, and they pick up the phone and they call ICE or some other law enforcement agent. Can they do that? Is that a HIPAA violation? And maybe Dr. Dark would like to address the ethical implications of that, but how would that play out?
Yeah, I was going to mention, I saw a question about how this is different from the Florida. So Florida was the first state to pass something similar to this. And the Florida, and it was actually in a statute, but the Florida statute specifically had in it that the information collected could not be shared with federal immigration authorities. The executive order does not have such a provision. And so while you declining to answer or an answer to that question cannot affect patient care, there is nothing about whether that information may or may not be relayed to immigration or to state law enforcement officers. Again, because I think the HIPAA exceptions will likely be interpreted to swallow the rule of HIPAA in this state potentially. So even though I think we would say at first glance, it sounds like a HIPAA violation, I think there would be a lot of different exceptions that could kick in. But Dr. Dark, I'd like to hear your version of that as well.
Yeah, in terms of the legal stuff, I have no idea. I feel like from an ethical standpoint, would a physician be justified in doing that? I feel like based on the guidance that we have from the American College of Emergency Physicians and the Emergency Medicine Residents Association, it would be clear that we shouldn't be doing that type of behavior, whether or not, a patient says that they're not lawfully present. When someone comes to us and they robbed a bank, we don't call the police and say, I have a bank robber here in the ER for, a broken ankle. That's not something that we do. So we shouldn't be doing it. I could almost guarantee you that there will be a case where that happens. And I think that's where we're going to test where that sort of provision that allows us to disclose information to law enforcement gets tested when it comes to HIPAA.
Yeah, could I just say, since I think there are some hospital GCs on the webinar, you might want to advise your intake people that that kind of phone call is incredibly risky to the institution. Because while there might be counter arguments, there's certainly a credible case that that constitutes a HIPAA violation for which the hospital could be liable for failing to give proper guidance to its employees. And so while, of course, you may have zealots who before or after this order might want to call ICE or something, I think for those employees to do so is risking some significant consequences to the hospital.
So I know we have additional questions, but unfortunately our time is up. So I just want to thank all three of you for giving really fabulous presentations. If you've been monitoring any of the questions coming in, quite a few people have similarly commented on how much they've learned today. So I also just want to mention that, actually, first, hold on, let me just put back